Legal article. ED has no right to restrict movement, confine people during search at their premises. Punjab and Haryana High Court. It is most heartening and most refreshing to note that the Punjab and Haryana High Court at Chandigarh, while championing and espouse the right to life and personal liberty as enshrined in Article 21 of the Constitution, has in a learned, laudable, landmark and latest oral judgment titled Dilbag Singh at Dilbag Sandhu vs. Union of India and another in CRM M 2191-2024 O&M and CRM M 3385-2024 O&M and cited in neutral citation No. 2024 PHHC 017817 that was first reserved on 2nd February 2024 and then finally pronounced on 8th February 2024 has minced just no words to make it absolutely clear that the Enforcement Directorate, ED, cannot confine a person within a premises during its search and seizure operation in a money laundering case. The petty tiners along with their family members were illegally detained by the ED from 4th January to 8th January when the search and seizure of their houses took place. It must be mentioned here that the single judge bench comprising of Hobieli Mr. Justice Vikas Behel, who authored this notable judgment, had made the key observation while setting aside the arrest of former Indian National Lok Dal legislator Dilbag Singh and another accused Kulvinder Singh in a money laundering case that pertained to allegations of illegal mining. In very clear-cut terms, it is pointed out by the court as an incontrovertible fact that there is not ing which stops the persons whose premises are being searched from carrying out their daily routine, including going to their offices, places of work. It is the bounden duty of all the courts dealing with such cases to ensure that what has been held so sagaciously in this lead ing case is observed more in practice than in breach. No denying it. At the very outset, this brief, brilliant, bold and balanced oral judgment sets the ball in motion by first and foremost putting forth in Para 1 that present order shall dispose of two petitions filed under Section 482 of the Code of Criminal Procedure, 1973, for short CRPC, i. CRMN 2191-2024 filed by Dilbag Singh at Dilbag Sandhu and CRMN 3385-2024 filed by Kulvinder Singh. Since common questions of law and facts arise in both the cases and also since both the petitions arise from the same Eser. To put things in perspective, the bench envisages in Para 6 that it is not in dispute that both the petitioners have till date, much less till the date of arrest, i.e., 8th January 2024, not been made an accused in the above said first. In Para A1 of the reply dated 22nd January 2024, filed in the case of petitioner Dilbag Singh at Dilbag Sandhu, averments have been made to indicate that even the petitioners were accused in the 8th verse, but on a specific query raised. Both Layer, Ned senior counsel for the petitioners, as well as learned counsel for the respondents, have fairly stated that the petitioners till date have not been made an accused in any of the said 8 verse. In the reply dated 30th January 2024 filed in the case of petitioner Kulvinder Singh, the facts have been correctly stated and the word petitioner has not been mentioned in the said paragraph I. A1. Since the above said FERs were registered under sections 120-B 411, 419, 420, 467 and 471 IPC, which are scheduled offences under Part A Paragraph I of the Schedule Append, Date to the Prevention of Money Laundering Act, 2002, hereinafter referred to as the 2002 Act, the Directorate of Enforcement recorded an ESR bearing No. GNZO 19/2023 dated 23 September 2023 against various accused persons, screen plants and stone crushers in order to investigate the commission of the offence of money laundering as defined under Sanjeev Sirohi Section 3 and punishable under Section 4 of the 2002 Act. A search was carried out from 4th January 2024, 08 to 5 hours, to 8th January 2024, 1300 hours, at the residential premises of the petitioner Dilbag Singh at Dilbag Sandhu and Rajinder Singh, located at 410, Friends Colony, Yamuna Nagar, and another search was also carried out from 4th January 2024 to 8th January 2024 at the premises of petitioner Kulvinder Der Singh, house number 62 sector 14, Uda, Yamuna Nagar. It is the case of the petitioners that they were illegally detained arrested on 4th January 2024. It is the case of the prosecution that petitioner Dilbag Singh at Dilbag Sandhu was arrested on 8th January 2024 at 12:15 p.m. from the above said house, and the petitioner Kulvinder Singh was arrested on 8th January 2024 at 2:20 p.m. from house number 62 sector 14, Uda, Yamuna Nagar. It is the case of the that searches were carried out at other places also. As per the case of the prosecution, the written grounds of arrest were given to both the on 8th January 2024. In the grounds of arrest with respect to petitioner Dilbag Singh at Dilbag Sandhu, reference was made to the above said 8 first, more so, FIR number 226 dated 14th October 2022, in which it was alleged that the plant and machinery of one unit was dismantled a year ago, but on the examination of sale purchase record, it was found that purchases had been made from 10th May 2022 to 17th June 2022 and the sellers with respect to the same were MS Mubarakpur Royalty Company, PS Buildtech, and the quantity involved in the same was 168830 metric ton, value of approx 8 to 4 crore, and the purchase records were not found on e-Ravana portal, which indicated that the above purchases were done through fake e-Ravana. In the said grounds of arrest, it was further stated that it had been found that an order was passed by the NGT on 31st May 2022 directing both JSM Foods Pvt Limited and PS Build Tech not to mine boulder and gravel on the mining sites in question, and wide order dated 18th November 2022. Huge penalties were imposed against MS Development Strategies India Private Limited, Delhi Royalty Company and Mubarakpur Royalty Company, and that during investigation, it was revealed that petitioner Dilbag Singh at Dilbag Sandhu was the authorized signatory in 2 of the bank accounts of Development Strategies India Private Limited, and his wife and son had invested huge amounts in Delhi Royalty Company. It was further stated that petitioner Dilbag Singh at Dilbag Sandhu had willfully adopted an attitude of not either evading the queries or giving misleading part evasive replies. Similarly, as per the case of the prosecution, the grounds of arrest in writing were given to the Kulvinder Singh on 8th January 2024, in which also the above said background was given, and thereafter it was stated that the said Kulvinder Singh through his relatives and close persons was also involved in the said mining activities. As it turned out, the bench then enunciates in para 7 that on 9th January 2024, both the petitioners were produced before the Special Court, PMLA, Gurugram, Haryana, and two separate applications were filed by respondent number 2 under Section 65 of the 2002 Act read with Section 167 of the CRPC seeking remand of the petitioners, in which wide two separate orders dated 9th January 2024, 7 days custody of both the petitioners was granted to the Enforcement Directorate by the Special Judge, Gurugram. On 16th January 2024, both the petitioners were produced before the Special Court, PMLA, Gurugram, Haryana for extension of custody of both the petitioners, and two separate applications were filed on 16th January 2024 under Section 65 of 2002 Act read with Section 167 of the CRPC for the said purpose. The Special Judge, PMLA, Gurugram, vide a common order dated 16th January 2024 was pleased to extend the remand custody of both the petitioners for a further period of 7 days. On 23rd January 2024, were produced before the Additional Sessions Judge, Gurugram, and vide a common order dated 23rd January 2024, both the petitioners were remanded to judicial custody till 6th February 2024 and since then, both the petitioners are in judicial custody, being lodged in Bhondasi jail. It is in the said background that the present two petitions have been filed. While concluding, the bench directs in para 76 that, as per the discussion herein above, both the petitions deserve to be allowed and the impugned orders deserve to be a. Non-application of mind and set aside on the following grounds: non-recording of compliance of the conditions stipulations contained in Section 19 by the Special Court while passing the impugned orders. B. Illegal detention, wrongful restraint of the petitioners from 4th January 2024 to 8th January 2024 amounting to arrest on 4th January 2024 itself and consequential violations of Section 19 of PMLA read with Section 167 CRPC on account of non-production of petitioners within 24 hours. Of c. Violation of provisions Section 19, 2 of the 2002 Act. Non-compliance of Section 19, 1 of the 2002 Act. D. For the sake of clarity, the bench clarifies in para 77 that the custody of the Enforcement Directorate is over and presently the petitioners are in judicial custody. In addition, the bench then directs in para 78 that, keeping in view the above said facts and circumstances, both the petitions are allowed and the impugned arrest orders, arrest memos along with the orders of remand passed by the Special Judge, Gurugram, and the Additional Sessions Judge, Gurugram, and all orders consequential thereto in both the cases are set aside and both the petitioners are ordered to be released forthwith unless their incarceration is required in any other case. Finally, the bench then aptly concludes by holding in para 79 that all the pending miscellaneous applications, if any, shall stand disposed of in view of the above said judgment. All told, it is high time, and all those who are in ed must definitely pay heed to what the Punjab and Haryana High Court has held so very elegantly, eloquently, and effectively in this leading case. It is made indubitably clear by the Chandigarh High Court that ed has no right to restrict movement and confine people during search at their premises. It is definitely the bounden duty of the ed to most strictly adhere to what has been held and refrain from restricting the move and confining the people whose premises are being searched. No denying it.